Order. The House is resumed. I declare the House in committee for consideration of the Holidays Amendment Bill.
Mr. Speaker.
Mr. Chairman.
Members, the House is in committee on the Holidays Amendment Bill. The first question before the House is that Part 1 stand part. This is on Part 1, Clauses 4 to 17 and Schedule Number 1.
Mr. Chairman.
I recognise the Honourable Trevor Mallard.
Yeah, only just, I think, with the bags under his eyes today. What was it? Do I call him? Well, he calls me quite a few things actually, but not normally from the chair, more from next to me in the caucus room. Mr. Chairman, as is obvious from some of the amendments which have already been tabled in the House today, and there'll be more to come, the Labor opposition is attempting to, at this committee stage, improve this legislation, not to the point where we think we will vote for it, but the point where we think it would be less offensive to workers. And I'll go through some of the amendments that we're putting before the committee so that the members opposite can give them consideration. And the first is around Clause 13, which would take out Clause 13, the requirements for an alternative holiday. Clause 13 provides if an employer and employee can't agree on when an alternative holiday is to be taken, the day must be taken on the day determined by the employer. The amendment will take that clause out because we believe that it's unfair for an employer to have the right to tell an employee that they must have a holiday on a particular date. And I give an example. They could, for someone who would otherwise be entitled to a holiday during the school holidays, they could require someone to take time off either in the holidays or outside the holidays, both of which are school holidays, either of which could be inconvenient. And what we want to do is to make sure that this is a genuine agreement, not one which is imposed on the workers as would be the case. Then what we're also making clear is that rather than it be something which is driven by the employer, it should be something that comes from an employee's request. There's been a lot of talk about choice from members opposite and about flexibility for workers. Well, let's just test them on that and with an amendment which indicates that these approaches should be based on choice. We will be having an amendment which inserts something which was originally in the bill around the question of the changes being informed and voluntary. And it's a question again is going to be a test for National Party members opposite as to whether the requests and the responses to the requests should be informed and voluntary. And because that is the essence of the argument that members opposite have been making, that these changes should be changes that are informed, changes that are voluntary. And what the government has done is remove those words. And just from our perspective, because courts do look at changes, they look when they're trying to determine intent. They do look at phases of legislation. I can remember going back to some of my earlier experiences in legislation, even as far back as the 1980s. The courts, in making decisions on particular cases, going to what was the intent of the Parliament, looked at changes that Parliament had made as legislation was going through. And the particular I think the particular case that I can remember was I think a Court of Appeal case which flowed from the rape law reform legislation, where they looked at the legislation that went in, they looked at the decisions of the Select Committee and determined that Parliament, so they went behind the final words of the legislation to the intent of the Parliament because of the changes that were being made. And what appears to be the case here, and I'd be interested in comments from the Minister and the Chair or other members opposite, is whether the removal of the words informed and voluntary could be taken to mean that in fact it doesn't have to be informed and voluntary because those words have been removed. And the other related suggestion around the proportion of annual holidays to be paid out is that they must be made in the absence of duress. Mr. Chairman. Mr. Chairman?
I call the Honourable Trevor Mallard.
Mr. Chairman, and it's certainly the view of the Labour opposition that these decisions should not be made under duress, so that they should be informed and voluntary and made in the absence of duress. Mr. Speaker, there's also questions around how often they should be used, and there's a series of amendments here which give the opportunity for the House to make a determination as to how often within a period of continuous employment these particular arrangements should be made. There's been, I think, a lot of discussion within the House on the question of whether the current arrangements, if an employer has any reasonable cause to believe that someone is throwing a sickie when they're not actually sick, that the current provisions are adequate. And therefore a question as to the necessity of this. And I will draw your attention, Mr. Chairman, at this stage to the regulatory impact statement as it relates to this section, or this group of clauses in particular, where it makes it clear that there's been no case that has been made and there's been a determination of the Minister rather than evidence. And I think we know, we've all heard the evidence of Business New Zealand and others who have said that this is not a priority area for them, it's not an issue which they think is important. I think it was just a case of John Key being slightly short of material for a speech to the National Party conference, and therefore, as a result of that, decided to give wage and salary earners a kick, because that's one of the things that Tories like doing at their annual conference. They like kicking people who work for a living, as opposed to being born to rule, as a number of people there. There's a question of which days are determined, and there's a number of public holidays which we will be focusing on as we move our way through. Mr. Chairman, this is there are a few things in this legislation where I think it's fair to say that there is an agreement across the House. I think there might be about 3 issues, and if we were dealing this in a proper way, dealing with this clause by clause, and I might say, Mr. Chairman, it is getting to the point of being ridiculous when you have a 19-clause bill that's divided into 2 parts. It is totally unnecessary to do, where the substantial parts of it are agreed, or clauses of it agreed, and the opposition are placed in a position of voting against stuff that they believe in because it is being tied up with clauses that in fact are clearly contrary to what most New Zealanders want. And if the Attorney General, who is in charge of drafting, in charge of Parliamentary Council office, dealt with that in a way which had some more integrity, I'm sure that we would have legislation where we could work through this in a way which I don't think would take any longer but where we could have genuine debate on the particular clauses and the way they fit, have votes on each of them, and deal with each of them on their merits. Mr. Chairman, I think the idea